The world is changing faster than ever before. In the past 10 years, there has been an exponential technological evolution, the kind of technology that has revolutionized the world of work as we know it.
The Lawyers Hub was founded on the principle that law needs to interact more with technology, and that greatly affects tech policy as well as access to justice. So the Lawyers Hub exists as a confluence between law and technology, working on tech policy, on emerging technologies, as well as increasing and upskilling the knowledge of lawyers in the area of technology. We support tech startups as well to ensure that the tech ecosystem also engages in policy, but as well understand the issues around data protection, issues that also concern their structure, as well as intellectual property.
If you look at the evolution of technology, it's been relegated as an alternative in most systems. But the realization that 21st century has brought us into is that technology has to be an integral part of our day-to-day systems. And if you look at some critical technology areas like artificial intelligence, blockchain, nanotechnology, biotechnology, then it gives us a strong indication that if we do not start having discussions on the use of these technology areas, as far as law is concerned, then we may be in some kind of trouble. So Lawyers Hub is leading the debate on the use of these technologies, especially in Africa.
Over the years, the Lawyers Hub has supported the innovation ecosystem, convened events such as the Africa Law Tech Festival and the Global Legal Hackathon. The Lawyers Hub has also supported government innovations within the justice sector, as well as trained government institutions and more than 10,000 lawyers across Africa on emerging tech policy.
Our dream at the Lawyers Hub is to have open access to law. We envision a continent where there is access to justice through leveraging technology and with a crowd of enlightened lawyers. We see a continent that also protects its own through better tech policies, that emerging technologies, through its regulation, will offer better value and consumer protection for the people within Kenya and within the African continent. We envision that we will convene policy makers, regulators, as well as lawyers who are more enlightened on emerging technologies and with better digital skills. And we invite you to be a part of this great vision for Kenya and for Africa. Good afternoon from Lawyers Hub. I hope you're fine and that you're doing well from wherever you are within the African continent. My name is Linda Bonyo, and you're joining us from the Lawyers Hub in Nairobi, Kenya. And thanks for signing up for this particular webinar. We're excited and extremely happy to be convening this with Startup Accra today. And so I want you to sit back, relax, and learn about data protection. The webinar today is focused on data protection for startups, and we are looking forward to an enriching discussion with my expert panel, as well as our colleagues in Startup Accra and my colleagues here at the Lawyers Hub. And so at this particular point, I'd want to introduce Startup Accra and have them introduce themselves, what they do, just before we proceed. We're extremely excited to be their partner in this journey. And so I'd want to invite my colleague from Startup Accra to proceed.
Yeah, hello, Linda.
Yes, Norbert. Sorry, Norbert.
Yeah, hello.
Yes, Norbert, we can hear you.
Yeah, good afternoon, and good afternoon from Ghana, and I trust you're all doing great. Yeah, so we are happy to do this with the Lawyers Hub Kenya. It's something that we've always wanted to do because we realize that one of the key things that startups face and mostly ignore is the fact that is the lack of the fundamentals, the legal fundamentals that they need to scale their startups. So you realize that some of them start and they start good, they forget the fundamentals, and once they are scaling, they end up facing legal battles and challenges and the nitty-gritty things that they should have considered before scaling their startup. So we came up as a team to say, how then do we help startups grasp the fundamental, connecting them to the experts, the lawyers, to guide them and hold their hands through this journey? And how then do we make it affordable and easily accessible for startups to have access to some of these opportunities out there? And we also realized the essence of tech startups adopting and knowing the fundamentals of tech law, which most of them do ignore. And to some extent, it's about the ignorance of the existence of some of these things. And we are glad to reach out to Lawyers Hub, who have been doing amazing within the tech space. And we are journeying with them on this project. And we are glad to have everyone on board. So basically, just a brief intro of what Startup Accra does. So Startup Accra is basically a community of startups and ecosystem players. Our core fundamentals is to bring together startups doing different things, just connecting them to share ideas, experiences, and most importantly, build strategic partnerships and collaborations, as we believe that is one of the very key and core aspects of helping startups grow on a sustainable scale. And we organize meetups. We partner with some key ecosystem players to provide some form of support to startups. And over the years, we've organized certain programs, and we are yet to officially launch our space as well. So basically, in a nutshell, this is what we do at Startup Accra. And my name is Norbert, and I'm the community lead for Startup Accra. So once again, Linda, thank you very much for having me, and we are glad to journey with you. Thank you very much once again.
Thank you very much. Thank you very much, Norbert, for that. We appreciate. And Ebia, I don't know how to pronounce that name, but she's going to make a point, I think, before we close as well. So I'd ask Ebi, please, could you proceed and say hi from Ghana?
So my name is Ebi Yakwa, Community and Partnerships. I work with Norbert on Startup Accra. And basically, we are just happy to be having this because it's something that we've been vouching for in a long time. And we are happy that Lawyers Hub Kenya is coming on board. We just hope that this is going to benefit so much for startups in our community. Thank you.
Thank you so much. Thank you. I really appreciate that. And so if you're joining us from any other country, please comment on the chat. Let us know where you're joining in from. We're going to have a poll. I'm not sure if the poll is ready to launch. We'll have a beginning poll just so that we have a rough idea on what to do. So you'll see a poll appear on your screen. If you could answer that question, please let us know, are you a lawyer or are you a tech startup? Are you a startup or are you a lawyer? Let us know so that we'll be able to know who exactly is in the room. Are you a lawyer or are you a startup or any other? There's a third option as well. Let us know on that. If you have any comments, the Lawyers Hub is on Twitter at Lawyers Hub Kenya. You're able to comment on the same. Please do. So we get that about, okay, let me not show the poll results until we are done, but I'm excited about the numbers as well. So thank you very much. We'll be having questions as well, and we'll have a presentation. So if you have any question, please feel free. We'll use the chat, we'll use the Q&A box, and then also we'll have an opportunity to take live questions. We'll unmute your mic. If you have a question, just raise up your hand, and then we'll be able to answer your question. At this particular point, I think if you haven't done the poll, we're just about to close the poll in another, I think, 20 seconds. So please just proceed to answer the question, and then we'll be able to proceed. Okay, and then we close the poll. Thank you very much. And now we share the results. We have 49% of lawyers on this particular webinar. We have 25% of startups, and then other people say they are 25%. So if you answered other, please let us know in the chat section what that is, what exactly maybe you do. Feel free to interact within the chat section. And so I want to introduce at this point Selina Onyanja from the Lawyers Hub. She's going to have a presentation on data protection before we move to our expert panel in a few minutes. And so Selina, if you're ready to go, please proceed.
Hello, everyone. Happy to be here with you guys today. we'll be going through the state of data protection in Africa, as well as the principles of data protection. I'd kindly ask Ken to beam up the presentation and just share the screen.
Okay. Thank you very much. Okay, as we put that together, I see there's people joining us from Guinea. Thank you so much. There's a data scientist, there's Laura from Nairobi, and then we have Rispa, who's a third-year student at Kenyatta University. Thank you for joining us as well. Just so you know, there's about 32 African countries that have already come up with data protection laws. I don't know how many of us have heard about the General Data Protection Regulations from the EU. We are going to be answering that in a few questions, even in a few minutes, even as we set up this. But I want to appreciate everyone. John Compson from Ghana. We have Gamfi from Ghana, who's also joining us. Brian Waweru from My Movies Africa in Kenya. Thank you so much for joining us, guys. We really appreciate this, and doing this on a Saturday afternoon with the time difference. It's 4 p.m. in Nairobi and there's a lot of traffic. It's 1 p.m. in Ghana, and in Nigeria, it's 2 p.m. We have Imo Joshua from Triple OK, who's joining us here. Abubakar Abdul from Lagos, Nigeria. Thank you for joining us. Andrew Penzi, who's a student at KCA University. Thanks for joining us. And everyone who's information security and forensics, thank you. We have Moses Malagan from Agro Innova Company Limited in Ghana. Thank you guys, and thanks for the work that you do in innovation, and we are committed to support you in figuring out the legal issues. And so the presentation is ready. I am going to put this back to Selina, who is a tech policy fellow at the Lawyers Hub, and is going to take us through the presentation. Selina, you ready to go?
Yes, I am, Linda.
All right, proceed.
Okay, everyone, if you notice, can I please have the next slide? So currently, out of the 54 African states, only 32 have data protection laws in place. And as much as these laws are in place, some of them are yet to be enforced, meaning there's nobody in place to ensure that these laws are being followed. Can I please have the next slide? So on this map, you can see the green areas indicate areas, countries in the region where the data protection laws are in place and they have been enforced. The yellow represents countries where the laws are in place but have not been enforced, and red indicates countries where there is no data protection law at all. Next slide, please. Now, when we talk about data protection, there are core principles that govern data protection. So the first of these principles is data minimization. This means that you as a data controller or data processor are meant to only collect data that you need from a data subject. The second one is accuracy. So it is up to you as a data controller or processor to ensure that the data that you collect, my apologies, is accurate. So you must ensure that the data is up to date and allow for data subjects to update the data or correct data that is inaccurate. Next is a storage limitation. So when you collect user data as a processor or a data controller, you must ensure that you store it only for the time in which you need this data. So once you're done with using the data that you have collected, then you need to stop storing the data. Accountability. So this goes without saying, you must take responsibility for how you process user data. You must ensure that it is done in a manner that ties back to the principle of fair, lawful, and transparent. And when it comes to purpose limitation, when you collect sub-user data, you must ensure that it is used for the purpose in which it is intended. So you must not use it outside the scope for which it is being collected. And finally, integrity and confidentiality. Now, it is up to you as a data controller or data processor to ensure that you secure user data. So this is all about security. Once you collect this data, you must ensure that you process it in a way that is secure. Now, there are rights that are accorded to a data subject once you're processing the data. So they have to be informed of the reason for the processing. They must be able to access their personal data. They must be able to object to the processing of any or all part of the data that you processing, and they must also be able to correct, delete any data that is misleading or false. They also have a right to withdraw consent in terms of processing at any point. And they have a right to data portability, which means that they own this data and they can take it at any point. Finally, there are obligations that come to you as a data controller or a data processor. So you'll notice that these obligations speak to each other. Can I please have the final slide, Ken? So you'd see that the data must be processed lawfully, and there must be consent, and you must be able to prove that the data subject has consented to the processing of their data. You must also collect the data directly from the subject, except in the event where you are a third party. Purpose for the collection must be explicitly defined to the subject so that they know for what purpose their data is being used. And you must not use the data for any commercial gain unless there is consent or it is authorized by law. So also when you're processing this data, you must ensure that you've put in appropriate systems to ensure safety, security, and that this data is processed in a way that is lawful. And finally, there must be communication. I would say that communication is probably the most important thing when it comes to processing user data. You must always communicate in the event that there is breach, and you must also appropriately communicate to the data subject on how their data is being used and for what reason. With that, I'll take it back to Linda at the Lawyers Hub. Thank you.
Thank you. Thank you very much, Selina. Thanks for the presentation. We appreciate that. As you can see, we've run you through the principles of data protection. And I know some of you are wondering who is a data subject, who is a data controller, and who is a third party. And so I'd want to invite my expert panel, and I'll begin from Olumide Babalola. I don't know how to pronounce that name really well, but Olumide is an accomplished Nigerian lawyer. He's spent quarantine the past 3 months. He's written a very good case book on data protection cases. And so he compares this from the EU as well as that is what is happening in Nigeria. He's also the author of a law dictionary that has been incredible. He writes on the area of data protection and is a digital rights advocate. I believe he is behind the recent case against TikTok, for those of you who are on TikTok. And so Babalola, please proceed to introduce yourself, and you can comment on the principles that have been outlined by Selina.
Thank you very much, Linda, for this fantastic initiative. And from the introduction, I see that this is an initiative that would continue to benefit startups in Africa. And then, I mean, it would help them to be conscious of data protection, their obligations, and the liabilities that may come from it. I see that Selina has spoken to the principles, she's spoken to the obligations, and I would always say that for every startup, it is just best for them to always appoint someone to see to their data protection needs, so that at the end of the day, whatever income revenue they have generated, they won't start using it to satisfy lawsuits and to defend lawsuits, because nowadays data protection is becoming bigger than it used to be. Even in Africa, we now have cases on data protection. We now have people going to court to enforce their data protection rights. And we now have regulators, especially for the countries where the regulators are active. We now have regulators breathing down the necks of startups as well, for them to fulfill their data protection obligations. So it is always important for startups to know their model, their business model, and how vulnerable they are to violating data protection rights. So once you understand that your model, because most startups, they always deal with data one way or the other, you would have something to do with data. You would have your access point, you would have your exit point, you would have your data sharing point, and all those things have their own liabilities that that startups need to be aware of. And once they understand their business model, then they can now be able to evaluate their possibility of violating data protection rights. They would have to, conduct risk assessment, conduct data protection impact assessment, because if your business centers around data, there is no how. There is a big propensity that you would violate people's personal data in the process of trying to do what you have set out to do. But once you have a data protection officer to look into all those things, because really every day we even as professionals, we get to violate these things unconsciously now. Today I was going to give a client a document that we had prepared for them. My assistant in the office had placed that document in a used envelope. It wasn't an entirely new envelope. It was a used one. It was an envelope that we got from another client, from an outsider. And I had to check. While checking, I saw that on the face of the envelope, it was addressed to someone. The person's name was there. The person's phone number was there. And that was the same envelope that my office assistant was going to use to send out a document to another client. That has grave data protection implications. But because if we are not conscious of these things, while even doing our businesses, we will always violate data protection rights of others. Then trainings are also very important. I'm glad Lawyers Hub has the capacity and the plan to periodically train people. I'm so sure you would have startups in your thinking as well, in your plans, because periodically, even as lawyers, even as professionals, we need to periodically train ourselves so that we understand the current trend. For example, when I filed the TikTok case, for some reason I have never used TikTok. I didn't even know about TikTok until I saw a month ago or two, when someone called me out of the blue and told me about TikTok's business model and how and I see that all over the world, TikTok is on the odd seat, so to speak. So I'm going to stop there, but the data protection principles are something we all need to familiarize ourselves with and understand our obligations, even as startups. Thank you, Linda.
Okay. Thank you very much, Babalola. And I'd want to just ask from the Nigerian experience. I don't want to bring wars between Nigeria and Ghana. I don't know who's the older brother, bigger brother, whatever. I'm not going to start that. But for the Nigerian startups who are joining us, I see several lawyers and startups from Nigeria who are joining. And the question would be, what are the practicalities of data protection from day to day? If you talk about a data subject, for example, give an example, we have a startup that maybe, maybe working together with, even in terms of marketing, maybe working together with an airline. I'm not sure Nigeria has an airline anymore, but we have maybe Kenya Airways, maybe working to maybe do their marketing or do their data collection online. What's the role of this startup? Are they a controller? Are they a third party? Are they the data subject? And somebody would be asking, does GDPR apply to me where I am in Nigeria? What would you tell them, Babalola? You're mute.
Sorry.
Yeah. Okay.
Yes.
You can...
Thank you, Linda. So whether you are a data subject, a data controller, a data processor, in Nigeria we call them data administrators, would depend majorly on your business model, like I said earlier. So if you only, without any other person's interference, determine the purpose, the means of processing data, you will strictly be a data controller. But if you collect data, for example, you've used an example of an airline. When an airline engages a startup to process some data for them, maybe their customers' data or their subscribers' data or the internet inflow, then in that case, most likely the the startup would be a processor. And even under the GDPR and NDPR, data processors and data controllers, they have very close obligations, especially when it has to do with protection, security of data, management of data. The fact that you are a controller does not mean that you won't respect the data subject's rights. So in every case will be determined on its own merits. But one needs to understand, like I said, most importantly, you need to understand your business model. And that is what tells you whether you are a controller or you are a processor. There are cases where a processor will also be considered as a controller. There are a lot of cases like that, depending on the kind of how you handle the data, whether you decide, the roles you play, most importantly, will determine whether, and that's why at every point in time, I can see that Techie has joined as well. At every point in time, you must understand your business model and you must seek advice so that you will know your obligations, so to speak. Either you would, most likely they wouldn't be data subjects. They would even be the one controlling the data or processing the data. So they would either be data processors or data controllers, or if they are in Nigeria, they are data administrators. And talking about GDPR, of course, if you process data of someone resident in European Union, yes, you will be subject to GDPR. Now, that people processing data of Nigeria, they are not here. We sued TikTok. TikTok is not in Nigeria. We also have a matter against some other foreign companies that we didn't even publish. They are not in Nigeria, but they are subject to the NDPR because they process data of Nigerians. And under the NDPR, such people need to be answerable to, and the same thing applies to the GDPR. Thank you.
I think what that means, what you're implying therefore, is that anybody who's looking to scale across borders must actually take in consideration data protection laws and any privacy laws, that come up in these particular areas. Because I see people say, you know what, I don't have any European clients, but at the end of the day, sometimes you need to look at the value chain. Where does your business begin? Where do your clients come from? And what sort of information are you coming into contact with? And two, I have seen incidences this past 2 months, especially during COVID-19, where some websites have been hacked. Some of you are building products. I think I'd want to throw this back to Olumide one more time. What would you talk about privacy by design? If I'm a developer and I'm building something, how do I ensure that I don't get people's data out there, but then how do I ensure also that my product, whatever it is, if it's an application, how do I ensure that I'm actually cognizant of data protection and privacy issues?
And this is, thank you very much, Lina. This is not even just about developers. It has to do with everyone doing business in this new world. I mean, the moment you are setting up your processes, your procedures, you must have data protection in mind. And that's when we begin to talk about privacy by design. The moment you are setting up any new product, any activity, any business activity, you must have data protection in mind, and it must, by the design, protect data, and also by default at the same time. So, in my book presentation, one of the presenters and one of the guests said something that's very profound. Data protection is international, it's universal. It's not just limited to any particular country, because you won't just say you know the data protection laws of your country and you don't know. Recently, just this past week, we've been doing stuff with some people in Canada, and we have to embrace ourselves with a PIPEDA that's applicable in Canada. And I understand that Canada is even trying to fuse all these data protection laws into one. There are cyber crime and all other related intellectual property laws. They are trying to fuse it into one, but COVID-19 has actually stopped them. So as a data protection enthusiast or a professional or somebody who does business around that field, you must be conversant with not just the data protection laws of your region, but internationally you must try to be informed, so to speak. And good to know these principles cut across. I mean, the same principle that Selena has spoken about is applicable to the NDPR in Nigeria. The same principle is applicable to Data Protection Act in Ghana. The same principle is applicable to Data Protection Act in the UK. The same principles are applicable to the PIPEDA in Canada. The same principles are applicable to CCPA in the United States. So Some of them might try to go, the extra mile. While we have 7 principles in some places, we have 8 in some places, we have 6. But all these things cut across. And we just have to be enlightened. And most especially as a startup, as a tech startup, your product will be used outside your country. Your product will be used everywhere. So you have to be mindful of people using your product and complying with their data protection laws. Just look at TikTok. Just look at Zoom. Just look at Facebook. Facebook is all over the place. Just look at Google. Google is all over the place. And so that's why you are, as a startup, you need to designate somebody to look after these things for you. Thank you, Linda.
Thank you very much. I think sometimes startups will say, I actually don't even have money to hire. I don't have money to hire a lawyer or a data protection officer. If you look at GDPR, the requirement was that they have a data protection officer in place to ensure that you're compliant. And now I'd want to invite Teki Akwete from Ghana. Teki is an accomplished lawyer in Ghana and across Africa. She's the founder and executive director of Africa Digital Rights Hub. They ran an annual conference called the Africa Data Protection Summit, which happened last year in November, I think November or December, which is an incredible place to network and learn. I'd want to just have Teki make a few opening remarks. Maybe she can just drop in on what we have been talking about right now on startups, accessibility to data protection professionals who can walk them through this particular journey. And because we've been talking to Startup Accra, it would be important to just get the view from Ghana. How does Ghana handle issues of data protection? And what should startups know in this particular case? Teki?
Yes, hi, thank you, Linda. Please permit me to go without the video. I don't think I'm made up for video, so I don't want to show my face. Yes, and good afternoon to all your panelists. And I just caught the tail end of the panelists that just spoke. Now, what I would really like to say in continuation to that is that for startups, I can clearly understand the challenges that startups face under data protection laws. Now, these are real challenges, of course. You know, first of all, even for the well set up organizations and entities, they don't have it easy when it comes to data protection, let alone, you know, the startups. One of the things that my organization, for instance, is trying to do is to demystify the whole issue around data protection. So whether you are in Ghana, Nigeria, or other places, what we want to do is to at least let, you know, startups understand the basic things that they need to know about data protection, and then have a basic understanding of how it should be implemented. And I would like to say one thing, that data protection is not just a lawyer's job. Even what we call data protection specialists, there are different kind of specialists. So for instance, you may have somebody in cybersecurity, you know, attending to data protection issues and having a lot of expertise around, you know, cybersecurity and its implication around data protection. And that expertise is very different from me as a lawyer that may have a broader overview. You will have a data protection expert that specializes solely in engineering and software designs and developments, you know, whose skill set is very different. And so for startups, one of the things that I will say is that the basic awareness is very important at the very beginning, basic awareness of what it really entails. Now, they would have to do a bit more homework if they don't have the resources, but it is also good to try as much as possible to engage the experts very early on. And I don't think, you know, every data protection and privacy experts you may approach, especially when you need help, is going to turn you away just because you do not have the finances to pay for their work. So you can really engage with a team of experts around, this is what I'm trying to do. Generally, how can you help me? And you could also put in place a number of strategies, you know, to engaging them or teaming up with them in the building and the development of whatever it is that you're doing, so that the payment, you don't have to pay upfront, you know, whatever, you don't have to pay upfront the experts that are helping you develop the work. So there are many ways of doing that, you know. Unfortunately, it is easier said than done. And one thing that I would like to say is that the law, as simple and as straightforward as it looks, when it comes to implementation in the different subject areas, are not as it seems. So if you are in the fintech space, you know, your understanding of the various principles or your application of them will be very different from someone who is just building, let's say, you know, a health application, or somebody who is building an agriculture application, an application for implementation in the agri space, or somebody who is even building a tool for implementation in the justice space. So these are some of the things that for the fintechs, they really need to know. And it's very important that they are proactive in at least having that basic understanding of the law. What does it mean broadly? What is the reason behind the law?
Thank you. Thank you very much, Teki. And I'd want to just get your comment, especially on people running, you know, websites.
Hello, Linda, I think I lost you.
Oh, sorry.
Can you hear me?
Yes, I can hear you.
Hello? I can't seem to hear you, Linda.
Anyone else who can't hear me?
I think I can now.
Okay.
Were you hearing me? I realized I got muted at some point.
No, we were hearing you, Teki.
Yes. So what I was just trying to say is that data protection can be complicated, but for startups, I think that the basic objective should be to really understand, you know, have a basic understanding of the law and its implication on their businesses. And then once you have that, you know, you can start digging further and then get some help you.
Okay, we lost you, Teki. Okay, Teki, we lost you for a minute. We'll just try.
Sorry. Can you hear me now?
Yes, now we can hear you.
Okay. Yeah, so I think that's essentially what I am trying to say, that, you know, we can start small, and it's very important. We shouldn't be over ambitious about, you know, meeting all the obligations. But what every regulator is expecting to see is that, you know, as a startup, you are really assessing what you're doing. You're assessing the risk around data protection, and you're taking some kind of proactive steps to address these.
I'd want to ask this, Teki, and also
Yeah.
to Bala, what would be your selling point? If can data protection be a selling point that can differentiate businesses? Can you advertise to someone and say, you know what, we actually this, and can that bring more business?
I believe so, and I think that is actually a greater selling, it even without laws. You know, I will advocate data protection and privacy as a self-regulatory measure, and the reason is that when it comes to your products and services, it stands you out as a business that is concerned about his or her customer, or client base who thinks about them and wants to do what is right by them. Because really, when you look at data protection laws, that is what it's all about. It's about protecting the individuals, all the clients that are accessing your systems and protocols, and protecting their interests. And so data protection presents you with that rare opportunity to, go a step further and show your clients or customer base that, look, I care about you. I care about what you think. I care about the information you're giving me. And these are the steps I'm taking to protect you and to protect your interests. And I think that those are the kind of messages, even as businesses, we try to put out anyway, every day. So if you have this system in place, it's a better tool that can help you, not just say it, but prove that you're doing something about it.
Babalola? Okay. Yes, we can hear. Okay. Please proceed.
Oh, sorry, I didn't hear your question,
So
Linda.
I'm wondering, can data protection be a selling point for business? And also I'd add it to Richard Josephs, who's asking a question around. He's in the landscape for e-commerce. What does data protection look like? I'd want you maybe to handle the question around websites. If I'm running a website, what do I need in order to comply with data protection? What are the good practices in this particular case, from your experience, Babalola?
Yeah. Thank you very much, Linda. I think Teki mentioned it. Yes, if customers are aware that you handle their data, their personal data, securely, you treat them with respect, you don't expose their data, you don't give them to people who could sell them or who could expose them to identity theft. Yes, I think you have the propensity to get more customers, and for your business to even be tagged as some world class or fulfilling some international standards. Yes, I think it's a selling point, and it takes care of whatever fears that your customers or your clients may have in the long run as part of their data and how they are secure. Now, talking about websites, and the question, I think I saw a question as far data protection in Nigeria and whether people have been sanctioned, whether people have been fined. Unfortunately, in Nigeria, I have not heard about any sanction for data breach. We've had a couple in 2000, towards the end of 2019, and we actually went to court for it. The matters are still in court now, but I have not heard anything about what, although in one of the webinars I attended, an official of the regulator mentioned the fact that they have sanctioned or to become public, but we're yet to see any of that. Now, talking about websites, what I'll look out for first is your privacy policy. That's the first thing I look out for. And that's how important privacy policies are. In some jurisdictions, they've been called privacy notices, but for whatever nomenclature you give it, it's just an information that you give to whoever is visiting your site or whoever is using your product on how data protection compliant your organization is. How do you keep, first of all, what constitutes consent? Does my visiting your site constitute consent? I need to know so that I know that I have consented to your use or your processing of my data for just merely visiting your site, especially for the sites that use cookies. And some cookies go the extra mile of tracking your location. So it means once I visit your site and you use cookies, then you begin to track my location. I've given you consent to begin to violate or invade on my privacy. Those things need to be clear on your privacy policy. What information you collect? I see a question about TikTok. If you look at TikTok's privacy policy and term of use, they collect a whole lot of information, and that violates to a large extent the principle of data minimization. They collect your location, they collect the model of your phone, they collect your locational data, you collect your voice, they collect your phone numbers, all sorts that they collect. But you see, when you visit and you don't look at all those their terms and their privacy policy, you don't even know what they collect about you, and you don't even know how they are kept or how they are used. So for a website developer, your privacy policy tells it all. Tells how people give their consent, tells what you use it for. It's very important. And we don't know how important, we don't know how the implication of some of these things until you meet somebody who is so privacy conscious. I had an event about a week ago or two, and we had people, we had voice recording, we had facial recording, we had a video played. And one would have just assumed in the past that, of course, all these things that were sent to me freely, I mean, that means I had the consent of the data subject to use them. But that's not true, because some data subject will tell you, I sent it specifically for the purpose of your event and not for marketing purposes. For example, I would expect that if Linda is going to use these our speeches, our panel discussions, she would specifically seek our consent to put it online. Those are the privacy implications that we would not ordinarily be concerned about. So for a website, your privacy policy is the first thing I'm concerned about. It tells me a whole lot about your privacy practice. It tells me a whole lot about how you secure my data. It tells me a whole lot about whether you share it with third parties. Now, some international organizations, I don't want to mention, based on their model, business model, they share your data with third parties. But if you check their privacy policy, they would not tell you specifically who they share with. And that's a violation in itself. So, rounding up, as a website developer, the first thing you need to concern yourself with is your privacy policy. Tell the people, the customers, the visitors, the prospective clients, what you do with the data, how you secure it, for how long you are retaining it.
Yeah.
And all those things is going to inform whether they want to continue to use your website or not.
So Victor Kenneth says this. He says, privacy policies are quite long, and I think it's sometimes a deliberate ploy to demoralize people from reading. And Brian says, I think privacy policies should be summarized in video form, since video is more engaging for some people. But also, in my opinion, I've seen some companies in the EU that are building up, cartoons that actually maybe a visual, an illustration of their privacy policy that is actually one pager, but it tells you everything about their privacy policy. Do you think that just long privacy policies are actually employed by lawyers to ensure we don't comply? But then also opportunities exist for startups such as these. Startups are very innovative and figure out privacy solutions that can actually be turned into technologies. What's your point? What's your opinion, both Babalola and Teki?
Yeah, Linda, I mean, I think that we've come very far, and especially what has happened in Europe has pushed all of us to become very much innovative about how we put out our privacy policies and our privacy notices, how we even obtain consent and all of that. That has changed significantly. Clearly, one of the things that in the last 10 years of data protection development all over the world has been that those long policies and notices that only lawyers do understand are not appropriate. And if you follow latest developments such as the GDPR and all that, you would even see that there are requirements in the GDPR that requires that even if you run a website that is, for instance, used for and by children, you should make sure that your privacy notices are such that, or policies, children that use that platform can understand. So we've come a very long way. And in the data protection ecosystem today, everyone understands that a long unwinding policy that doesn't really say much, that is not difficult, that is not easy for the ordinary person to understand, is not a good standard. And so it's something that is even frowned upon by regulators across the globe. So that is what I will say about that.
Babalola? Yeah, okay. You're still on mute.
See.
All right.
Okay, so I'm back now. So Teki she made a fantastic point about making privacy policies very attractive and not making it unnecessarily long and not making it unattractive for people to read. Yes, I remember we did something for a client, a couple of Ridwan just logged in, Ridwan from Nigeria. We did something for a client, a tech startup. I mean, tech this thing, and their privacy policy was quite animative. I mean, they used a lot of animation, and they were quite good to read. Then, of course, Ridwan also mentioned the fact that now it is advisable to use layered notices now, so that it's just so brief and summarized. The major factors or the major requirements need to be there as to consent, as to what it is used for, as to how it is shared, how it is protected. Then the voluminous and the very comprehensive version can be kept somewhere such that when you click a link on the website, it can take you to where you can find the voluminous privacy policy. But most importantly, the important factors, and I know even under the NDPR and GDPR, data controllers have the responsibility to make it as simple as possible and understandable to the layman. So once you're and I understand that there was a decision recently where a data controller was sanctioned because the privacy policy was not clear enough and it wasn't explicit enough, and he didn't fulfill the purpose it was meant to fulfill. So I think it should be as attractive as possible.
Okay, thank you very much,
Linda. Yes, I just want to add something to that. I think that anytime anyone is developing, whether it's a policy or a notice, the key objective to helping you do it right is your audience. So, you know, whether or not, it's not about just going to copy a particular policy from somewhere. It's more about who are you writing this policy or notice for, who is going to use it, and that should inform the language, that should inform the style and the approaches that have been spoken to so far.
That's true. Thank you very much, Teki. We're going to take one poll at this particular point, just to find out what your thoughts are on this. There are two questions on this poll. It says, on a scale of 1 to 5, how important is data protection implementation to you as a startup? 1 is low priority, 5 is high priority. And the second question is, do you have in place a data protection policy for company and user data? Please proceed to vote so that we'll be able to know what that looks like for you. Okay. There are several questions, and so as we proceed, we'd want to take some live questions. And so I'd want to just have all the hands down. So if you have a question, please raise up your hand so that we'll know that you're ready to speak. I saw David Ross from Tanzania. I'd want to just allow him to speak. David?
Hi, thank you, Lawyers Hub, and thank you, Linda and Olu for putting together this insightful program. In some countries, like in Uganda and others, there are fines that are levied against companies who have non-reporting of customer breaches. So, for example, I believe in Uganda, if you have a breach of your customer data and you do not report it immediately, which I believe is determined within like 24 hours of the breach, you have the potential to receive a fine from the regulator for up to 2% of the entire annual revenue of a company. I'm unaware of any fines that have been levied against companies, as I believe that would likely, potentially, ironically, even be private. But I wanted to see if there are similar laws on the books for non-reporting of breaches, and if there's any news stories out there about that. Thank you.
Thank you very much, David. We'll take a second question from John Karuri. John, you have a question? Please proceed, John.
I'm okay. It has been, it was the same, I'm okay.
All right, thank you very much. Alan Mulama, you still have a question? Alan Mulama. And we'll also allow Samson Makodual. You have a question? Samson? Okay.
Can you hear me? Can you hear me now?
Yes.
All right, sorry about that. Yes, mine also relates to communication of breach. In Kenya, we have an interesting clause whereby a data controller is obligated to report a breach within 72 hours to the data commissioner. But when it comes to the data subject, that obligation exists certain exceptions, whereby the data controller may delay a report or a notification or may restrict the information on the basis of his right to not self-incriminate himself in the event that that could lead to an offense for which a conviction may lie. So the question then becomes, is this a limitation, number one, when we're looking at balancing the rights between the data subject and the data controller, whether this is an appropriate limitation? But even more importantly, I'd like to hear in other countries whether they have a provision for the data commissioner or the supervising authority to actually refer a breach to a prosecutorial body for the purposes of prosecuting an offense. For example, if you look in the Capital Markets Authority, that authority, in the event of a breach of law, can actually refer that to the Director of Public Prosecutions to deal with that offense. Now, under DPA, we don't seem to have that provision because we are trying to say we are protecting someone from self-incrimination, but there are sufficient protections to ensure, therefore, that the data commissioner does not initiate a criminal investigation on his own motion, therefore, really negating the whole purpose of this clause. So I'd just like to get some feedback from perhaps Nigeria or Ghana if they have anything similar and how they've dealt with such cases.
All right, thank you very much, Sam. We'll go to someone from Ghana, Gyamfi Bediako. The name is really hard, but please, if you could proceed to ask your question. I see somebody's from Cote d'Ivoire, but we'll go to Bediako first. Please proceed.
Hello.
Yes.
Hello. I don't know whether you hear me.
We can hear you.
That's right. I have a question, but my question may be quite okay. It goes this way. Around here in Ghana, one thing that I notice is things like some of these banks and even telecom companies. They take our details and they have personal details, phone numbers for internet banking and things like that, and they use it for marketing. You find people sending text messages for lotteries, and some of them you simply cannot unsubscribe. When you try to unsubscribe, it sends you a message that you haven't subscribed to this, and yet it keeps coming every time. You see, so now I don't know. I think now that Techie is hearing me, and I found out that Ghana is one of the few places in Africa where you have data protection laws. I want to find out who is responsible for this kind of things and why aren't anything being done about it. Thank you very much, and thank you for this wonderful program.
Thank you very much. We'll take I think a final question from Rachel Asewe. Rachel, you can proceed to ask your question. Rachel? Please unmute from your end, if that's okay. Okay, we have lost Rachel, and so Rachel, you're speaking? Sorry, there's a problem with your mic, Rachel. Okay, so I'll take Michael Maina instead. Michael?
Hi.
Yes.
Hello. Hi. My name is Michael. I run a startup very roughly in the digital content creation in the aviation industry. And I was wondering, when you want to be compliant to data protection laws, who do you consult? Do you go to your web developer? Do you talk to a lawyer who's conversant with these issues? Should you talk to, I don't know, a cybersecurity specialist? What's the first step for a startup trying to be compliant to data protection laws? Thank you.
Thank you very much. And Rachel wants to speak again. So Rachel, we'll just try it one more time to see if this works. Rachel, please proceed. Rachel? No luck with Rachel. So we're going to answer all these questions together. I think if we have time, we'll take another round. But Lilian Obeto is asking, are there generic policies in place which one can use when establishing a lending platform? And then we also have, I think the question that was asked before, the digital marketing. Somebody's asking, Boris is asking from Nigeria, from Ghana, I want to know if there's a function of DPO in Ghanaian law or Nigerian law relating to data protection like Cote d'Ivoire. We had somebody from Cote d'Ivoire as well, if they could continue to maybe just comment on the chat as well. Somebody else has been asking on the chat, as a startup, there's not enough funding to appropriate for all areas in this context, such as policies. What advice do you have for startups in deciding how to minimally achieve effective data protection policies? And so we'll try to answer these questions between myself, Olumide, and as well as Teki. So Teki, I think I'll ask Teki to go first. And Teki has, at the forefront of Ghanaian data protection policies and laws. I think you need to let us know what exactly you did in the context of Ghana, and what startups can benefit from that as you answer the rest of the questions.
Okay, so I was there within a short time, and I would not say that we did enough to, help startups within the period. But I believe that maybe the commission at the moment is still continuing in that drive. In terms of helping startups, when I was at the commission, I believe it's a very important thing that every regulator, especially in our context, should think about doing. There's a number of reasons for it. Data protection is a highly technical area, so to speak, and it involves a lot of resources, i.e. knowledge and skill, which is very expensive all over the world. And so as a regulator, if you want to really help, especially the tech startups, if you want to really help them, I think one of the best ways to do that is to create an ecosystem that allows for easy compliance and facilitation of those laws. Having said that, that is also one of the objectives of the data protection of the Africa Digital Rights Hub, and then some of the things that we're trying to do with the Data Protection Summit. Last year, we launched the what we call the Code of Practice for digital IDs in Africa. It's a starting point. Subsequently, we are thinking about doing a similar thing for AI and AI and big data. We're thinking about Code of Practice also for fintech, and then maybe to some extent other kinds of specialized fields. The reason for these COPs are to simplify the process so that it's very easy for anybody to take the recommendations or compliance requirements and then implement it their own way. There was a question about DPOs as well. Under the Ghanaian law, there's a requirement for a DPO, and it's clearly stated. The issue about notifications, breach notifications, most of them are under African laws, but as has been rightly stated, different countries are dealing with it differently. In Ghana, of course, the ultimate sanction for non-compliance with a breach notification will be, some kind of either sanction from an administrative sanction from the regulator, or a criminal sanction that may be initiated by the regulator if you do not take the notification requirements under the law. I think there was another question, but I just have lost count of them. So if it comes up again, I believe I will speak to them.
Okay, that's okay. Baba Lola.
Thank you, Linda. Okay, so I put down a couple of questions here. So talking about fines, I have answered that. Nigeria, we have not, to my knowledge, we haven't fined anyone yet. But of course, our own Nigerian data protection regulation provides for fines in the event of breach, in the event of data breach or violation of the regulation. Now, notification, our regulation is not elaborate on notification. The extant regulation is not elaborate on notification yet, although the regulator is trying to issue some guidelines around the enforcement of this thing, but we have issues or we have reservations for some of the guidelines because they seek to, with respect to the regulators now, some of our guidelines seek to create rights, they seek to create obligations on their own, they seek to create new provisions on their own rather than procedural provisions on enforcement of the already provided regulation. Now, communication of breach, I said, regulation, the NDPR does not have elaborate, or I have not even found any procedure on communication of breach. Now, reference to the Director of Prosecution in the event of breach, yes, although we still don't have elaborate provision on it, but I think because it is an offense, and in our own case, a breach of our data protection regulation is a breach of the Act itself, and the Act provides for some criminal sanctions and criminal provisions. So in the event of a breach, of course, the regulator can always activate that procedure to see to the prosecution of such an offender, so to speak. Then for someone who says that, that's Ghana anyway, where banks sell and where they allegedly sell and sell people's data. Nigerian situation, yes, the NDPR takes care of that, provided you are able to prove it that it was the particular bank that sold your data, that are procedures for you to follow to be able to ventilate your rights in court. Then who do you consult when you have as a startup? Taking mention the fact that data protection, and I appreciate the fact that it was mentioned on this platform because we keep saying it. Data protection is not the exclusive reserve of lawyers. There is data security, there's data engineering, there is the technical part that are not necessarily advisory, so to speak. So, the engineering part as well. So, if the data protection professional focuses on those areas, trying to secure data breach, trying to secure acts, trying to secure unlawful intrusion into data, those are also data protection, but they are not necessarily legal advisory. So I would suggest that while you have your website designers, your website builders who might be able to advise you, or the technicians who might be able to advise you basically on the kind of security apparatus, security media you can use, or the techniques you can use, I would still prefer you engage a lawyer or you consult a lawyer who can also give you a broad, just like Tiki said, a broad perspective to advisory, and especially when it has to do with drafting of contracts or doing some other serious legal business. Then generic policies in place, yes, and that's most likely where you get lawyers involved. Drafting of the privacy notices, privacy policies, the data sharing contracts, or the contracts between you and your employees, the internal contract and the external contract. You might have to get lawyers involved. In Nigeria, talking about the question of DPO, yes, Nigerian data protection regulation has a provision for DPO, but again, it is not elaborate. Not like the GDPR, where it provides for the qualification of a DPO, the obligations of a DPO, the independence of a DPO, the resources of a DPO, the duties, the elaborate duties of a DPO. Nigerian data protection regulation does not have that. But of course, we can always borrow. We can always borrow from other jurisdictions. I think I've tried to cover most of the questions I've written down.
Yeah. Yes, Linda, sorry. Yeah, I think the Babalola helped bring out the ones that I had forgotten, and I just wanted to touch on them. who do you consult? It really depends. Now, I like to approach it from, right at the beginning when you're thinking about the ideas. Have everyone around the table. Even within, I think it's very important for startups to, have somebody within their team who may be, enthusiastic about data protection to start reading around it and building some knowledge and skill around the data protection issues. So at the team level, it starts from there. Everyone around the table should sit and have the discussions. What I normally, whenever I consult on data protection issues, I would have in the room the engineers. I would have in the room the technical people. Sometimes I would have in the room the HR and several other components or key departments within the organization, to have the discussion, because they all play a key role. And it's very important. It's not, the domain of one particular expert. All the lawyer does is to help you navigate the challenges around it. But the lawyer needs to know and understand the engineer properly to be able to do that. The lawyer needs to understand the software developer and how they are going about the collection of information in order to advise appropriately. So you need all these experts around the table in order to come to some kind of reasonable solution on what is the best approach to data protection for us or otherwise.
Okay, thank you.
Yeah. Linda, do you mind me adding something quickly to that?
Please proceed, Norbert.
Sure. So I totally agree with what Teki just submitted. One of the things that most startup founders, especially tech founders, pretty much ignore is the fact that they need to understand what data protection is. So you realize that at the end of the day, there's a disconnect between who is doing what in the team. They don't understand what some of these core components are. And funny enough, sometimes what they do is they just go to a website that's similar to what they do. They copy their privacy policies and just dump it on the website just to keep the website up, which is so much wrong. And at the end of the day, when they grow, when they're about to scale, they raise some funds and they end up being sued. So instead of using that money to scale their startup, they end up using those funds to fight legal challenges. And these are use cases that you wouldn't hear out there. And these are things that startups are battling internally. So I think there should be more sensitization on startups, helping them understand the essence of data protection. And it's good that we're having this conversation. Then they will now go to their team and dissolve it within the team. So everyone is on the same page. Data protection and privacy is a very big deal. And it's going to be a selling point and position the startup and propel them to scale. So yeah, I pretty much agree with what Teki said. And I think we'll be glad to keep this conversation going and see what the outcome will be. I'm really glad, and I can't wait for us to collaborate on something. So yeah, thank you very much.
Thank you very much, Norbert. That's Norbert from Startup Accra. I'm going to ask a few questions before we go to the last round of this. We have a poll. That's our final poll. And so we are just going to ask you, in whatever level, have you received a warning or a legal notice regarding data protection? Have you received a warning or a legal notice regarding data protection? Has someone ever even written to you and said, please take down my data, whatever it is? And so we have, you can vote. We have about maybe another 20 seconds before you finish voting. Have you ever received a warning or a legal notice regarding data protection? And
Linda.
Yes, Teki.
Yes, there was one other question about who is responsible for, ensuring, notifying breach, especially when it comes to sale of personal data. When it comes to data protection, apart from the regulator having a responsibility, you would see that a lot of the actions the regulator has to take is tied to a complaint. So if you ask me who is responsible in ensuring compliance, I would say that the one whose, you know, rights have been breached and the regulator. And it always starts with the one whose rights have been breached taking a proactive step in notifying the regulator that this is what has happened. Or sometimes even the laws give them enough powers to take, you know, the data controller or processor that have breached the laws, you know, to court themselves. So it almost always starts with the person that has suffered harm at the end of the law.
Okay.
Thank you. Linda, if I may, quick reaction to what Teki just said, but that's not cast in stone, with respect, ma'am. It's not cast in stone, especially in cases where there's a data breach and the data subject is not even aware. I mean, we've had cases, I mean, of course, the GDPR contemplates situations where data is lost or data is manipulated by an insider. For example, the W.M. Morrison's case. I mean, it might take a while before the data subjects will know that a disgruntled employee is planning to publicize their data to the world for some ulterior purposes. So sometimes,
yes, I agree.
not even be aware.
I agree with you, Babalola, but that is why notification is important. He was talking about a situation where somebody has sold their data or used it for direct marketing purposes, you know, without any, in those cases, yes.
I agree. Okay, I agree.
Thank you very much. I think I'll close the poll at that particular point, and we have 55% who have voted, and 84% of this say they have never received a warning or a legal notice. 9% say yes, and 8% say I would rather not say. So that's perfectly okay. I'd want to ask, point you to give you a few pointers before we take our final round. I want to ask you a question, and if you can write a few things here. Please, could you, if you have a notebook wherever you are at, could you please indicate a question? Do we have a record of processing activities? How do you process data? 2, do you have a procedure in which you have employees receive data, process it, and also share that data? Do you have that within your organization? Is it possible to come up with that? Do you have a policy on retention of personal data? Babalola had pointed this out and asked that how long do you keep people's data? You need a procedure on retention of data. It can be even a one-pager that simply just indicates what exactly that is. Then do you have guidelines on data protection by design and by default? This can help you as a developer if you're building products so that you have products that have, you know, privacy ingrained within that particular product. Do you have a procedure on data protection impact assessments, you know, so that you know before you launch a product, you know that this is how it affects data protection, this is how it's going to affect our clients, the data that we already own or whatever we are going to bring. And then finally, do you have a policy for incident handling? Is there a way you handle, you know, incidents in this particular case? Do you also have an information notice to employees? Anybody who's handling data, do you have that particular policy? Then do you have policies on transfers of personal data? Do you also have a procedure on data subject rights? Because you have some subject which is, that means maybe your customer or whoever comes in contact with your particular data. Also maybe your resolutions, your meetings, how exactly is that data shared? Who comes into contact with it? You know, I think you must take a very internal look at your startup to ensure that you have all these templates that would be able to help you. Bediako from Ghana had indicated that they developed some website for businesses and they were working on a mobile app which required a privacy statement page. What they did was to look for some other websites and adopted it to suit, you know, this particular client. Is that okay? I think data privacy policies should actually be very personalized, because sometimes you indicate that within that privacy policy, maybe it indicates that this will be settled through arbitration and arbitration shall be done in Hong Kong. Meanwhile, you're in Ghana. And so you don't notice until, you know, this go wrong, anything goes wrong. So I think you need to look at that as a startup. So we have about 7 minutes to get this done. I'm just going to take in, I think a comment from Deborah Rogers, and then we'll have our closing remarks from our panelists because they have to go. Deborah?
Hello, everyone. I'm saying hello from The Hague, and I really appreciate the concept of data rights as universal human rights. And I'm curious about what anyone thinks about data ownership, because to me, to your point, Linda, about it becoming most personalized, our medical data, obviously during Corona or during COVID-19 is, you can't get more personal than your own health. And in most countries, clearly in the United States, this is a big problem. We have no rights to ownership of our own data. And blockchain and hyperledger permissioned blockchain and different sort of things that are being designed for us to have the key to our own data is something I really would love for you all to talk about. And then my second part of this is, have you noticed any trends during the COVID era? You know, we're condensing an era, an epic turning point in history into these last 2 to 3 months, and trends happening very quickly. I used to be a clothing designer, and I watched trends happen in the 80s and 90s on the global, international, and financial world. And I'm curious about what trends you all may have been seeing that you could sort of forewarn those of us in justice spaces or startup and design spaces. Thank you very much.
Thank you very much, Deborah. And I think I'll start from Teki. Teki is actually convening, I think, a webinar on the 29th of June to, I think, Deborah's question on COVID and data, and I think contact tracing as well. So Teki, could you go first?
Yes, so on data ownership, it is a very tricky one. Fundamentally, some of the reasons behind data protection is also the recognition that my information belongs to me, and so I have a right to determine how that information is used. But with time and looking at how technologies are developing and how information is being collected and processed, it's become invariably challenging for this right to be, you know, fully given to individuals because of how this works. In Europe, however, the GDPR tried to, I think this was one of the reasons behind data, the right to data portability, you know, so that one can be able to collect whatever information is there about them in one state and then move it into whatever other space. And so the notion of data ownership is recognized by law. However, I believe that in practice, it tends to be a lot more difficult to implement because of the technologies that are out there, you know. With the COVID and the emergencies around it, I don't think the issue is that you do not own the data, but then there's a public health and safety element of it, which means that aspects of that data should be made available for the protection of everybody else. And so that's where the challenge is. And for some of us, we believe that even though under you know, fundamental right to privacy and even under data protection laws, there are exemptions to, you know, emergencies, national security, public health and safety and all of that. These emergencies, you know, should be dealt with in a way whereby they continue to respect some basic tenets under data protection laws. So the fact that, you know, it's an emergency and you're collecting my health data for purposes of COVID does not mean that, you know, I lose my rights entirely under data protection laws. It does not mean that you can collect anything you want. It does not mean that when I want access to that information, I should not have it. And so when you look at data protection laws, these are all spelled out. The problem is that it's an emergency and we are not seeing a lot of our governments, you know, talking to the data protection regulators in order to do this or collect the information and use it in a way that protects the individuals. And that's what we are doing on the 26th. We're trying to speak to a regulator, we're speaking to a technology person, and then also a data scientist on how safe to do these things, still recognizing laws such as data protection and under other fundamental rights.
Thank you. Thank you very much, Teki. So we'll go to Olumide. Thank you so much, Teki, for your comments. I know you have to run, but we really appreciate. We are going to be sharing Teki's contact as well on the chat box before we leave. We'll be done in about 10 minutes. And so I'll ask Olumide, please proceed. You're still muted, yeah? Please mute and
okay. Yes.
Wait, I can
Thank
hear
you very much. Okay, so on data ownership, chapter 13 of my book is dedicated to data ownership. Unfortunately, I agree with Teki. Unfortunately, the court's decision on data ownership are not favorable yet. The courts still do not recognize data ownership. The court still do not recognize the property rights in data. The court still looks at data strictly from the prism of being information. Information as an intangible thing, and it's not the interpretation of the court has been that it's either it is choices in action or choices in, so if it's not choices in action and it is not tangible enough, then the courts have interpreted, unfortunately now, that data is not capable of being owned as a property now. But looking at the way things are going, I would, with some level of circumspection, disagree with that position, because right now, if data can be protected, if it can be transferred, like rightfully noted, then yes, the property rights in data should be protected. I mean, it should be recognized. But so far, I haven't seen any authority that supports that. Then talking about the COVID situation, yes, Teki mentioned it. Data protection is not an absolute right anywhere in the world. It is subject. It has to be balanced with some other rights, and there are also derogations. So, in considering the situation, the prevalence of COVID around the world, yes, there might be times that the data protection rights will be derogated upon, but what we still need to be sure of is the balancing of all these things, and the fact that at the same time, the principles of data protection are respected. The one I have had an issue with that we have got to court against is the violation of data minimization principle. You can't say because you want to take my data to protect COVID or to get information about COVID, then you take all the information there is in the world. I mean, so it has to be minimized. It has to be limited to the data that is necessary for the purpose you seek to achieve. You can't possibly take my data. I mean, you take it at large. So that we're in the Federal High Court challenging that, but unfortunately, COVID has not also allowed us to have a date for the matter to go further. But we'll see where it leads us afterwards. So that's my take. That's my take on that. Thank you, Linda, for the opportunity.
Thank you so much to both our panelists for also taking the time to join us today. Unfortunately, we're having some issues back at the Lawyers Hub. So I just wanted to close off by saying thank you for taking the time to be with us today. And a huge thank you also to all our attendees, and most importantly, Startup Accra for making this happen. I think it's been a great learning session for everyone, and we look to keep this conversation going. I don't know if Linda is back on the call. If not, we'll allow for maybe one more. Oh, okay, perfect. I think Linda is still having issues joining the call. So we'll allow to keep, we'll keep the chat open for about 15 minutes or so, just to keep the conversation going in case there's anything else we can share in the chat, any contacts that you think are relevant for all the startups that are joining us. I think we can keep the conversation going in the chat for a while before we close the webinar. Thank you, everyone.